YouTube and Facebook universe. This is Gary Berger. I am doing my Facebook Live Ask a Lawyer show, which is pretty exciting. So, last year, I certainly did a lot of this. So, we decided during the pandemic, with the pandemic, that we would um, do a weekly live Facebook show. And we did it. We did a show every week for about a year last year. And then, as with the pandemic, what we want to do and what people do is we give ourselves some breaks. We don't push ourselves too hard because the pandemic and working from home and doing all this stuff can be stressful. So after doing the Facebook Live show for about a year, I gave myself permission to take a break from it, and and we're back. So what I'm trying to do is we're trying to find a pace at which to do it, but I have many clients and friends and other folks that enjoy the show and folks that want to see more of it. So we're doing it. So as with the other shows we've done before, we're going to ask legal questions. We're going to answer legal questions. We're going to answer them for free, and we're going to give people free legal advice to try to help them. And we're going to have questions coming up on the comment line. So if you have any questions or any things you'd like to ask about law or life or my fish tank, you can ask them anytime, anywhere. I'm doing this one from home today, and we do them from different locations to give people have fun. I do have my cat that's sleeping over there in that chair. I did a Zoom here a little while ago. She was on my chair and clawing at me the whole time. Let's see if she comes over. All right, let me answer the first question. Kaylin asked, can you explain Illinois dog bite law? Yes, I can. So in Illinois, if you're bitten by a dog, you have a claim against the dog owner. Dogs owners have they say there's no bad dogs, just bad owners. And I'm an owner of a few dogs. So and why don't I go, and if I can find them, they're over here in the house somewhere. So dog owners have an obligation to keep their dogs from biting and keep their dogs from doing that. Now this is Winston. Hey, Winston, you're a good boy. And these are two of our other little dogs. Now they're just in a cage now just because foster, and one of them's a recent acquisition. We do a lot of dog fostering and trying to find homes for them. My wife's like amazing at it. But regardless of whether or not you own or possess the dog, like I have a dog now that's a foster, but I'm still responsible for it. I still don't want it to bite people or anything like that. You have an obligation to keep your dog safe. We just settled a case 2 weeks ago for $110,000 in Illinois. The case was in litigation. We were about to go to trial. The other side finally came up and paid us what was fair. And in that case, our client was helping her daughter's boyfriend's mom move. And when they got to the house, they were unpacking stuff. Their dog came out and bit her on the shoulder and had multiple injuries. We made a claim against that person. I have a newsletter. If anybody wants my newsletter, if you don't subscribe to it, email me at gary@bergerlaw.com. We'll get you copies. We write about these cases. This case will be in my newsletter, probably going out today or tomorrow. And we allege that dog had vicious propensities, and that the dog wasn't on a leash and attacked our client. The claim was under both attack by a client and premises liability. In Illinois, you must show that the dog has vicious propensities Sometimes it's called a one bite rule, but it doesn't necessarily have to be a bite, but it can't be the first time this dog has ever attacked someone or without any notice. In this case, we had evidence that the dog had bitten a trainer's hand, and certainly the dog wasn't leashed. There's other different ways to get liabilities. You have to prove that the dog owner was negligent. So they're negligent either having a dangerous condition of the property, having a dog that attacks people. They're negligent in having a dog separately that a dog that attacks people. So if they're out in a park or the dog runs off it's not just on their property, but it's on other property. So, and when you invite a guest to your home, that guest is responsible for the safety, that the owner is responsible for the safety of their guests. So you have to make sure that your dog doesn't attack people. It's basic common sense, but it also rises to the level of negligence. So they violated that. The dog was not leashed. The dog was dangerous. Our client didn't do anything, and they bought her multiple times on the arm. And so we made that claim. So you have to show negligence. You knew or should have known. Knew or should have known that that dog was going to bite someone. They knew or should have known they failed to control their dog, and that happened. So that's the basic legal part. It's not that complicated. Now, it does get, dog bite cases can be tough because you have to make sure you have insurance that covers the claim. So we were able to make a claim against the homeowner's insurance company. We're usually not in the business from taking people's personal money. We try to take insurance money because it's a lot easier. It's very difficult to get people's personal money. Those people have insurance. It covered the claim. We were able to make the case. Now, it did not settle easy. Excuse my sneeze. It did not settle easy. However, we were able to, we filed suit. We did depositions of the case. We got the evidence that we needed. We were ready to take the medical depositions that we needed, and we were able to get a great settlement. It's a very large settlement, over $100,000 for a bite. There was concern. So the medical can go different ways in a dog bite case. You're waiting for the scars to heal. So they're sewing those up, and then after they heal, you have concern about scarring and whether or not you need plastic surgery to mitigate and decrease the scars. You also have concern about rabies. So you immediately go to dog control. You go to domestic animal control, whatever that's called in your area, and see if there's rabies. They get a rabies tag. So they've had their rabies shot. The dog has had the rabies shot. So then the person doesn't have to get rabies antiviral medication or anti-rabies shots. If you can't track that down, the person may have to get that prophylactically. That can be expensive. In this case, we had an unusual twist in that the client had to get antibacterial injections and had bacterial blood infections from this. So that was a little bit of a twist. You also sometimes have people with broken bones or other worse things. Sometimes it's very sad. The scars are on the face. And that is very tragic and sad. A couple other things with dog bite cases. Remember that just because you know the person who had the dog doesn't mean you shouldn't make a claim. So what do you do if the person whose dog you know is the person whose dog attacked you? That's not unusual. In fact, that's more common than having a stranger's dog attack you, because you don't go to strangers' houses. You don't go hang out with strangers and their dog. Many, many times it's someone you know, and you know their dog. Now, you may not be best buddies with them or whatnot. So the point being, and that happens in car crash cases too. Well, gee, I was in the car with the person who was driving and they were negligent, they injured me. And I'm like, so I don't want to make a claim, or I'm concerned about that. Well, listen, you're only making a claim against their insurance. If you were my friend and you were at my house and my dog attacked you, or if you were in my car and I got in a wreck and you got hurt, I would want you to make a claim against my insurance because you're my friend and I want you to get compensated. And I feel bad that I was negligent, let my dog attack you, or I was negligent and I got a car wreck. So, it is more normal than abnormal that you know the person who owned the dog. It's more, and that happens. So make the claim. Ask them who their insurance is. Say, listen, I need to get paid for my medical and whatever scarring I have, whatever disability I have, whatever pain and suffering I have. Those are your elements of damages. So I've just outlined basically what the negligence is, what you have to prove, what some of the medical conditions are, and then talked a little bit about the claim against the insurance and who the parties are. Make the claim. We send lien. One of the challenges we have is making sure there's insurance, making sure the person has a home where homeowners insurance will cover it, has some other type of insurance will cover it. That's our inquiry a lot of times at the beginning of the case. We're trying to identify that. Sometimes the homeowner never responds. So then we're forced to file a lawsuit to do that, to find out who their insurance company is, to get the insurance company involved, because the homeowner doesn't want to take responsibility for their actions or their dog's actions. So that's the case. Remember too, Kaylin asked another question. What if there's no puncture wound or blood? I have had a number of cases where there is no puncture wound or blood. I represented a woman who was attacked, was pushed down by a dog, fell backwards, broke her wrist, and had wrist surgery. And then about 6 months later, there was a thin fracture. She had continued pain and actually had a surgery on the other wrist too. I had a case with a man whose dog, the person had the dog on the leash, but the person wasn't holding the leash. The dog came around, twisted around the man, made him fall, make him break his arm. It doesn't have to be a bite. A dog can attack and be aggressive and cause another injury. As long as you're able to prove proximate cause, then you're fine, then you're good, then you are able to succeed in the claim. It doesn't necessarily have to be a bite. The woman that I'm thinking of, my client, ended up having surgery. She was actually a pianist. It affected her ability to play. She played in her church every Sunday. She had significant damages from that. So we've had success in our firm in having dog bite cases where we get 6-figure recovery for our clients. But remember, just because you're bitten by a dog doesn't mean you should get that much of money. It's a function of your injury. Sometimes you're bitten by a dog or snapped at a bug, where you're not severely injured and you don't need a lot of care. So your injury and your damages inform us as to what how much money you're going to get, how much money we're able to get for you. So there's a lot of hoops. We got to prove liability. We got to prove damages. We have to fight the other side. Sometimes we file suit, push the other side to get that. If you have any questions about dog bite cases, go to our burgerlaw.com dog bite pages. Email us at info@burgerlaw.com. We answer questions for free all the time about this. We're happy to do so. There was one other thing about dog bites I was going to say. I've tried dog bite cases. They're great. They're very interesting cases. A lot of times the owners of the dog, if they're not going to give you the insurance, if they're going to fight you, they're not going to take responsibility. They're going to be those types of folks that don't want to stand up and take responsibility. It'd be amazing the evidence that we find that they're attacked other people and this and that. Like, why were you I had this trial where why were you so worried? My dog has never attacked someone, never attacked someone. Well, then why were you so worried? Why did you warn this child to stay away from the dog 10 times before the dog, busted into that room, jumped on this kid and bit him? Oh yeah, well, we were worried because he bit 3 other people. Well, you know what? Hello, it's not coincidence, and dogs can be dog aggressive, not just people aggressive. Okay. Oh, you just saw Sadie go in the background. That's Sadie. That's our other dog. So if dogs are dog aggressive and they're attacking, if you're walking your dog, another dog comes out, attacks your dog, and you get pushed down or bit. We had a case. I'm gonna tell you one other war story on dog bites. I'm gonna move on. We had a case where a woman had a finger off case, where a dog came into her yard, attacked her dog. She went in to break the fight up, to try to break it up. Her own dog didn't know it, bit her finger off at the tip. Very tough dog. It's very painful. We recovered. We won the case, got a significant recovery for that client. So we had to fight that hard, though. What we do and I think this sometimes sets us apart from other firms. We file suit, we litigate, we push it. It's our obligation to get full recovery for our clients' injuries. We take that obligation seriously. We do what we need to do as lawyers appropriately to use our civil justice system to resolve the claim, to resolve that claim. Let me move. I've already answered that question too long. I happen to be wanting to talk about dog bites because I'm sitting here at home and I got these different dogs that I'm about to go take out and hang out and play with a little bit too. All right, let me move on to another question. I have a question from, sorry, I'm on my computer too while this, Zach Miller. Why hasn't the state of Missouri paid what they owe corrections officers? Zach, thanks so much for that question. Let me bring all of our friends and clients who work for or used to work for, who have family work for the Missouri Department of Corrections up to speed on that issue. The case on a decision handed down. So visit our page, Missouri Department of Corrections, on the Burger Law website. Google Burger Law, Missouri Department of Corrections. Click on the link. You'll get the latest. We have everything ever in the case, but at the top, we should also have the latest deal. And on June 1, 2021, the Missouri Supreme Court handed down a case that was good and bad for us. They reversed the money judgment of $113,782,000 or $86,000 and change we got. However, we won a number of issues in that appeal. The Supreme Court found that the state of Missouri's sovereign immunity defense was no good and we could make the claim. They found that there was a contract. They found that the state of Missouri breached the contract. They found that the class was properly certified and should go to trial as a class and was appropriately, and Class D certification was appropriately denied. They found that 2 of the 7 activities that corrections officers are forced to do by the state of Missouri without pay were compensable as a matter of law automatically. When officers are picking up and retrieving equipment, usually radios and keys, and they found that when an officer is on duty and expected to respond and is actually acting as a guard, as having to be vigilant, it is around around prisoners, criminals, that is compensable. But they found that because we had won summary judgment on 4 to 5 other activities, that on a summary judgment standard, we went to trial on damages, that there wasn't enough information in the record, and it directed us to go back to trial to have the trial judge determine whether those 5 other, 2 are as a matter of law compensable, 5 of them may be still compensable and we can still go prove it. The court asked us to go back and prove whether or not those 5 were compensable, or whether the officers have to be on duty while they do that other 5, or if they get their keys and radios or do a compensable event and then do other stuff and then take their post. It's called the continuous workday rule. So if you do a compensable activity for your job and then later on you do things that aren't necessarily compensable, you don't have to prove that everything is compensable. If you start work and you clock in and you're working, you're on the clock, you got to get paid, and that's not fair for a employer to that out. So we're going back to trial in the case on June 7th, 2022. For all my corrections officers, clients, and friends, I represent you all. The Supreme Court said we were properly class counsel or class reps, other stuff. If you have information about this case or would like to be a witness or have us talk to you about being a potential witness, please call us. Email me at gary@burgerlaw.com. Call us at 314-542-2222. Give us your name and your information. We also have a form at the Burger Law Missouri Department of Corrections website page for people to update their information. I've had a lot of people say, hey, I updated my information, or my father died, or my mom passed. Are we still in the class? Yes, you are. We made a provision in the last order. This case is going a long time, and it is profoundly sad to me. Now, look, justice delayed is justice denied, and we have officers who are passing. They're old, or they're whatever happens in life. I mean, we all should have gratitude for the lives we have, and I am committed that if an officer passes and has money due them, and we will win this case, again, that they're going to get paid. Okay. We yesterday, I've been doing a lot of work in the case. We yesterday redisclosed our expert on damages. We produced that report to the other side. They're going to take his deposition. We're going to do a couple other depots, but essentially the case is done. And we're going to go to trial in June of 2022 before the court in Cole County, Missouri. And the Supreme Court directed that trial judge in the court to recalculate damages, not try the whole case again, not do the whole deal, determine the compensability of those other activities, or whether or not they're on duty and expected to respond at the same time, or whether they apply to this, whether the continuous workday rule applies, and recalculate those damages. So we redisclosed our expert. We recalculated the damages to bring them up to speed, because we had last recalculated those damages effective August of 2018, and we need to redo the numbers for June of 2022, and we're going to be redoing that. So Zach and any other officers watching this, that's the deal. Okay. And if you have any other questions, please email me, please reach out to us, or go to our website page for answers. I want to jump. I have a lot of questions coming through on the feed. I'm going to just keep going. I'm going to try to answer these quicker too. Daniel von Seckendorf, I hope I got that right, Daniel, asked, Gary, what does the mandatory reporting process look like for dog bite in St. Louis? And then there's some other questions. Let me ask that. So what does the mandatory reporting process look like for dog bite in St. Louis? In St. Louis, in Missouri, in Illinois, there is mandatory reporting for all dog bites. So if you or anybody you know is bitten by a dog, Google who the appropriate authority is for animal control, call them up, report them. They will take that dog. They will quarantine that dog. You're welcome, Zach. You're welcome. They will report that dog, and they will make a record that there is a dog bite of that dog. If the dog, and then they will check the rabies with that dog, the rabies vaccine status, and they will report to the injured party that that dog has a rabies shot and they're good, or they will say, we don't know, there is no record of rabies, and they will quarantine that dog either at a facility or at home if they trust the people who own the dog and they seem responsible for 10 days. They'll make sure that the dog does not show indicia or symptoms of rabies, and then they will advise the bitten party, and they will keep a record on that. That record's important because if the dog has a later bite, then you've proven the vicious propensity or the prior bite on the part of the dog, and that helps you in liability. You can prove to the owner that you had noticed that this dog had a vicious propensity, and so there you go. And then he also asks, and this is Daniel's question. So I answered the first part. What does the mandatory reporting process look like for a dog bite in St. Louis? Second question, are there implications for your dog even if they're up to date? Is eviction possible if renting? Let me ask the second question. Yes, there are implications even if they're up to date, because although your shots are up to date, you still have a dog that bites people. Now, it could be a one-off bite or you can also have learned your lesson and you're always going to leash your dog. I read there was an article yesterday out of Colorado where a dog was killed by a moose. My friend Bob showed me the article. Bob and I saw some moose a couple of weeks ago. I was in Colorado. In Colorado, people when you walk with your dog off leash, and I've been guilty of that. I've had a lot of dogs, and many that are good trail dogs for me. We'd walk them off leash if you're back in the woods in Missouri or Colorado or wherever you are. But when you get near someone or an animal or something, you gotta leash that dog up. I have a little clip on my belt where I put my leash, and now my wife actually makes me leash my dogs better. So I've learned from her, among many other things that my brilliant, smart, beautiful wife has taught me. So there you go. So anyway, an unleashed dog got killed by a moose because the dog ran up to the moose, and mooses are 1,000 pounds and tough, and they killed that dog. Very sad. So Daniel, if you got a dog, so are your shots up there? Yeah, but you have a prior bite. Now no animal control is not going to make you put your dog down for one bite unless it's a really vicious attack against a child or something. But if they get 2 bites or 3 bites, they may have to put your dog down because they show you're not controlling your dog. And I'm not judging you, Daniel. I've been there. So I had this dog named King. King passed away 2 years ago. Very sad. But King was a biter. I mean, the post office wouldn't deliver to my house. I had to get a PO box. And I had to do a lot of work with that dog. We got an invisible fence. He was always on leash. We had to really watch out, and he was moody, and it changed the way and how vigilant I had to be with that dog because I knew that I had warning to that, and I reacted to that. So Daniel, 1 bite, it's a warning to you. So you got to take extra precautions with a dog that is dog aggressive, people aggressive, or nervous or something like that. Is eviction possible if renting? The answer is yes. If you're a landlord, you do not want to have a dog that's going to attack the other neighbors or the other tenants in that building. It's possible, but I think with most landlords, if you approach them and say, hey, listen, man, I'm taking good action now with my dog, that's better. Let me go to another question. I see Brennan has a question. I've been thinking about door cams as evidence. Have you had any of that come up? Thank you, Brennan. How are you, Brennan? Good to see you, my friend. I haven't talked to you in a while. I love seeing your question. For Brennan, I just want everybody to know, for Brennan, this is a very in-the-box question. Usually Brennan's asking me about bees or other random stuff because he's a very creative man. But this is kind of like right down in there. So, yeah, Brennan. So I actually got a referral from a case from Nextdoor. There was a Nextdoor cam thing. There was a thread on Nextdoor. 2 different of my friends and clients said, call Gary Berger if someone had a legal problem. We got the name, we called them. We're trying to help those people. We're representing those folks. Door, yes, absolutely. We have a Ring camera. I know other people, it's becoming the thing. It's very safe. It's great. I just did Halloween with my kid about 2-3 days ago with my little boy. Super cute, love him. And a lot of those doorbells were Rings, I just saw a lot of them on Halloween night. Brennan, I'm glad you have a bee question waiting. Nice. I need to go actually give my bees some more sugar water right now because you feed the bees a lot of sugar water going into the winter months so they have plenty of fuel for the winter. Ring cameras, yes, they are evidence. But, for the kind of cases that usually come up, I mean, a Ring camera or a door camera is not going to work for a car wreck or in a park or something. So if the incident happens to happen there, if there's a slip and fall on ice when someone's coming to your door, shovel your driveways this winter because an Amazon driver, he's an invitee to your house and you know it, or melting and refreezing, you got to do that. So that's great evidence, Brennan. I'm going to put that into my list of all the people in my firm who are watching, Rodney, Kaylin, everybody else. Let's put that on our list of questions to ask our clients about. That's a great idea. Let me move on to another question. Rodney asks, what happens if I'm partially at fault for a car accident? Sorry, my nose is itchy. I was sneezing, but I moved out of the sun, but it's coming back on me. What happens if I'm partially at fault for a car accident in Illinois? If you're partially at fault for a car accident in Illinois, what do? Make the claim anyway. So in Illinois, if you're partially at fault for a car wreck, you can still recover for your damages, but your damages are reduced by the percentage of fault attributed to you. So if you are 10% at fault in a car crash case, you should get 90% of your damages. If you're 48% at fault for a car wreck in Illinois, you should get 60% of your damages. However, Illinois has different laws that if you're more than 50% at fault for your car wreck, you do not recover. So it's okay to be partially at fault, but if you're more at fault than the other driver you're making a claim against, Illinois law says you should not recover anything. So that's an issue that we assess in car crash cases in Illinois. We've done a lot of these cases, car, truck, motorcycle crashes in Chicago, Northern Illinois, Middle Illinois, Southern Illinois, and we assess fault. We are candid and transparent and give clear and direct advice for our clients about the impact of comparative fault. And this idea is called comparative fault. You compare the fault between the parties and how that impacts the claim. We tell our client, listen, your damages are this, but you're a little bit at fault. The other car failed to yield, but you were going a little fast. The other car should have yielded the right of way to you, but you came onto that stop sign. The other car, we have this case, the other car was in the middle turn lane and then jumped over to the side. You thought you were clear. I think it's totally their fault. But for folks listening, remember, don't believe or trust necessarily the statements or position of the other side. If you're talking with a claim representative that says you're 10% at fault, you don't get anything. That's bullshit. That's not true. Oh, sorry. That's BS. That's not true. Claim agents and the other side in a case may say a lot of things to you to dissuade you from making a claim, to lower the value of the claim so you will settle. Don't believe that. Read my book on our website about the little tricks claim agents do. Call us for free answers to questions, to your questions about that. We're happy to answer your questions for free. And sometimes we do that. I've tried cases where I've said, listen, folks, the other people did this, and this wrong. Here's what we did wrong. And we're going to be responsible for that. So when we walk into a claim, we're going to own and be responsible for our role, for my client's role in the case. But let's look at the other thing, what the other party did. And let me talk about the one other issue in this, or at least one other issue in this, is there's a difference. There's a significant difference between someone who does negligence, or speeding too fast, or failing you right away, they're going too fast, and then the other driver tries to react as quickly as they can. So a lot of times I have cases where the other side says, oh, your client did this, and this. And I say, listen, my client reacted within seconds to an unusual situation of a speeding car, failure to yield the right-of-way turn in front of them, a 80,000 tractor trailer skidding on a highway, or changing lanes into thought was a blind spot. My client reacted the best they can. So there's a distinction with a difference. If my client is reacting as well as they can within seconds, then it's not fair for you to give them a bunch of negligence for what they did and give them a high percentage of a negligence versus a truck driver who made the decision to drive too fast versus a motorist who decided to go 90 on the highway. That's not a fair comparison. So the distinction with the difference when people are reacting quickly. Let me move to another question. Jennifer asks, what if my medical bills are more than my available insurance? Jennifer, that's a great question. So remember that when you're injured, your damages are your medical expenses, your wage loss damages, your pain and suffering, and your and whatever disability or disfigurement you may have, and those damages into the future too. You may have situations where your damages go out in the future for a long time. You may not. Remember, too, the minimum insurance in Illinois is $25,000. The minimum insurance in Missouri is $25,000. So you may get in a car wreck where your bills and your bills are $50,000, but as we find out later, the defendant only has $25,000. So that's one of the things we address right away in a case. We are asking the defendants right away how much insurance they have. In Illinois, there is a code of state regulation that mandates that they give that information, that they disclose the limits. That in Missouri, there is no such requirement. Sometimes in cases with significant damages, we file suit right away in order to be able to find out the limits of insurance so that we can gauge and inform the client of the recovery. Is the maximum insurance 25, 50, 100, etc. This also interplays with a person's underinsured motorist coverage, which I'll talk about in a minute. So if you make a claim against a defendant and your medical bills are more than the insurance, that's a problem. You are not going to get adequately compensated. So we have conversations with clients and we say, hey, and I'm just moving, sorry to get out of the sun just a little bit because it's moving on me. We say, hey, listen, man, sorry, you can see all my art on my wall. I like to have a little bit of art in my life. And you can see my my kids. We were hitting baseballs this morning before we went to school today with my little guy. So what we do when we settle or resolve the case, we can use lien reduction statutes in Illinois, or we can use lien reduction statutes in Missouri, where we will take, for instance, a $25,000 fee, a $25,000 total settlement, or $50,000 total settlement after the attorney's fees that we charge. We don't charge by the hour, we charge by a percentage of recovery we get only if we win the case, not if we don't get a recovery. We never charge if we don't win. And then we give as much as we can to the client, and then we take a portion of that and we pay the medical providers, and we contact the medical. We spend a lot of time contacting medical providers, asking them to reduce their lien, reduce their amounts. I teach classes to lawyers on how to deal with liens. If you Google lien reduction, how to handle and resolve medical liens, my article on it, my white paper on it, is usually the top hit. We take this very seriously because it puts more money in our client's pocket. It is very important to get as much as we can to settle the case for our clients. However, it's also very important for us to put as much in our client's pocket as we can after the settlement, which means reducing the medical liens as much as possible. We have various techniques and tricks to do it. We contact the providers saying, you had a free lawyer, got you this money, you would reduce this money if there was health insurance, etc. So we use the lien reduction statutes in Missouri and Illinois. The lien reduction statute in Missouri is much stronger than in Illinois. We reduce the liens as much as possible. Sometimes we invoke the lien reduction statute, which says that in Missouri says that after recovery, the client gets, take the recovery, you take out the attorney's fees and expenses, and the client gets half, and the medical providers have to share half. A lot of times that means the medical providers have to share a third, and then we break down pro rata that third money going to each of the providers. And we have a system way to do it. We have an Excel spreadsheet. We do this. We're experts at it. I have other lawyers ask me how to do it. If there are ERISA liens or Medicare and Medicaid liens, that's a little bit of a different story, and there's different ways to handle that. But we still regularly and always reduce Medicare and Medicaid liens. We also reduce ERISA liens. Liens asserted when health insurance, if your health insurance pays for your medical care, and if it's an ERISA plan, not a state-only plan, but a multi-state plan, and they're asserting a lien under the Employment Retirement Income Security Act of 1974, then we have ways to handle those ERISA liens too. They can be aggressive against us, but we're very successful in those too, because we want to get those folks paid. And a bunch of lien holders have to know, and if you're a lien holder watching this, our clients have no incentive to settle a case if all the money goes to a bill collector or to a ERISA lien holder. So those folks get it. And the people who are good lien holders and get it, they get it. They get it. Say, listen, if you cooperate with us, we will give you some recovery. But if you don't, you're never going to recover anything. And they're always understand, and we will persuade them to the wisdom of our position if they do not. And we're right. We're not right because we're slamming the table and saying, you have to listen to us. We're right because we're right. So if you have medical bills that are more than the insurance, it's probably even more important that you hire us, because we can get you a great recovery and we can get rid of that debt. One problem people do sometimes is they say, oh, my medical bills are so high, I'm not going to make a claim. And then they carry that medical debt, and you read all the time, medical debt drives people into bankruptcy. It's crazy these days. So if you have high medical insurance and low limits, it's even more important to come to us. Because remember, you also, and I said I was going to come back to it and I didn't forget, remember you also may have underinsured motorist coverage. So that means it's even more important to get the maximum policy limits from the tortfeasor. So if a guy hits you or a woman hits you, you get 25 grand from them. You may have $100,000 in underinsured motorist coverage. We get the $25,000 from the tortfeasor. We split that with the lien holders, as I've said already, and then we make the underinsured claim, get the second recovery, the big recovery. We just did this in a bunch of cases. We're doing it all the time. They also fight us hard. We also have to file lawsuits against your own insurance company, our client's own insurance company, to get a recovery. And then we also have to pay the lien holders out of that too, but they've already been paid once, and we usually cut a better deal. And in the second claim, the underinsured claim, we can put more money in their pocket. If you have other questions about liens, it's a complicated area. I'll send you my white paper on it, how to negotiate and resolve liens, for free. We use it. We use it for our people all the time. Our staff is really, really good at resolving and lowering liens. So I got a lot of other questions. Yeah, Rodney says we had one case where we did get the whole accident on a Ring camera. Let me answer another question. All right, let me do. So because I'm already talking about underinsured claims, let me throw up a question that Genevieve asks. Can you explain the situations where a phantom motorist claims might arise? How do you get insurance coverage for those situations? Can you combine coverage if you have multiple vehicles on your policy? Great questions. All right. This is going to be a 7-minute answer. So if you're bored, you can tune out for 7 minutes. But if you want to listen to it, hey, let me ask you this. Why didn't the skeleton cross the road? Because he didn't have the guts. That was the joke that my 3-year-old presented on Sunday night on Halloween. At first he kept saying the punchline right away. Then he explained, you got to wait for the other person to say, why didn't he cross the road? And then you deliver the punchline. So we're working on our delivery. Can you explain situations where a phantom motorist claim might arise? Yes, I can, Genevieve. Phantom vehicle or phantom motorist claims arise where you get hit by a car and the car leaves the scene and you don't know who they are. When you're in the car, okay? Happens all the time. It's a hit and run. And you can't do anything about it. If that happens, you have uninsured motorist coverage to cover that. In your own policy, it is mandated by law that you have uninsured motorist coverage that covers a phantom vehicle. If you get hit and the person leaves and you're injured, go get your medical care, call us up or ask us a question at burgerlaw.com, and then we make a claim and we go against your own insurance for your minimum $25,000 in uninsured motorist coverage. In Illinois, the uninsured motorist coverage minimum is $25,000. You can have more. And so that happens. We also have cases where that happens and you get the license plate and they catch the person later. We've had many cases where they get the license plate and they get the person later. or the truck driver someone else catches a person, pulls them over. Truck driver pulls over 5 miles down the road. I didn't know. Yeah, right, you didn't know. It's bogus. So we catch them too. And if you catch them later, the claim is against them because they're no longer a phantom or a ghost or a hit and run. You caught them. You make a claim against them. Sometimes you catch them and they still didn't have insurance, so you still have an uninsured motorist coverage. Sometimes you catch them and you had better coverage on your own insurance. You wish you wouldn't have caught them. But it is what it is. And then then you may have an underinsured claim. So if you get hit and run, you'll pay premiums on your own insurance, make the claim against your own insurance company. Do not worry if your premiums are going to go up. Most of the time they won't. You're in the claim anyway. You already are making a claim against your own insurance company for the property damage. You get your car fixed, you can drive to work. So you're already making a claim. They already know about it. It's not going to change your premium. I literally switched my insurance last week because I realized I looked at my premiums and my premiums were hiking up, and I was like, this is not. I went and shopped it and I got cheaper insurance. I hadn't done it in 5 years. And then this isn't just a story for this question. It literally happened. Point being, even if your premiums do go up, even if they are going to punish you because you got hit by a phantom vehicle, 20 years, you have the first claim and they hike your insurance, you're like, that's bogus. Go shop your insurance. I guarantee you can find as good insurance for cheaper price or the same price. So try that. How do you get insurance coverage for those situations? You have insurance coverage for those because if you're on the right-way driving, you're legally required to have insurance, so you have insurance. In your policy, you automatically have insurance for that, even if you didn't ask for it, because insurance companies are not allowed to sell or have insurance in states unless they provide automatic uninsured motorist coverage. It's built into your premium. You're already paying for that, even if you didn't know it. Question: can you combine coverage if you have multiple vehicles on your policy? Yes. Well, let me answer. It depends. Sorry. That's why we have lawyers. It keeps me in business, right? If you're in Missouri, you have a phantom vehicle coverage, you have multiple vehicles, your uninsured motorist coverage minimums of $25,000 will stack. You will have, so if you have 3 cars, phantom vehicle hits you, you have $75,000 in coverage. If you have 2 cars, you got 50, 1 car, 25. You can do the math on the other possibilities. If you're in Illinois and you have multiple vehicles on your policy, whether they stack and whether you have more coverage, the answer is it depends. It depends on the language of the policy. Some policies combine uninsured and underinsured coverage. They may give you $100,000 in coverage. They may say you can't stack or combine other policies. They may not say that. It depends on the language of the policy. You'll never know because no one ever reads their policy. But what we do is you hire us, we contact the insurance company, we say, send us the policy. We say, what's your position on amount of coverage? They tell us, we check the policy, see if they're right. If they're wrong, we persuade them to the wisdom of our position. If we can't persuade them, we file suit until we keep persuading them of the wisdom of our position. If they're right, we tell you, the client, we say, listen, here's the deal. This is the policy you had. This is how much coverage you had. Let's do it. Let's do it that way. And then, or let's get that amount of coverage. So that's uninsured coverage. That's phantom vehicle coverage and how they stack or may stack. You have a claim against your own insurance always for that. Asking for a friend. She had a slip and fall accident. She lives in Illinois. Does she have a claim? Absolutely, she does. If the homeowner had a dangerous condition or the business owner had a dangerous condition on their property. So if you own property or own a business in Illinois, you have a non-delegable duty to provide your guests a safe place to be. You can't have hidden holes in your property. You can't let water melt and refreeze on your front walk or on the entrance to your property and have someone come and slip and fall and injure themselves. You got to shovel in ice. You got to fill in holes. We have a case right now against a major retailer. You can't have a door, those automatic doors with those electric eyes. You can't have a door that closes on people and knocks them down, where you don't call the door repair company, or you call the door repair company and they don't fix it, because you know that's happening. You can't have trip hazards. You can't leave wet, spilled drinks on a floor for 2 hours where you know your customers are coming, and have them fall and get injured. People get seriously injured. They break bones, and it drastically affects their life. And you also know that in like the Walmarts of the world, they got signs here, buy this, buy this, buy this. And they don't, and you gotta, and they expect you to, and they say, well, you're not watching the floor. Of course I'm not watching the floor. You're giving me 50 signs to go buy all this stuff. I'm watching the floor as best I can. So if accident in Illinois, call us with the facts and circumstances. We jump on this stuff. So what do you do if you're in a slip and fall in Illinois? Notify the manager, notify the homeowner, notify immediately whoever it is who owns or controls or is responsible for that property. Tell them right away, name, information, find any witnesses. Take a picture with your phone of the soda on the ground, of the hole in the grass in the yard, of the ice on the parking lot that you didn't see. This happens all the time. You go out to a parking lot, there's no ice anywhere, everything's clear, and you slip on some black ice or ice on asphalt that you couldn't see. Like, what is that doing there? And how come no one did anything about that? That's ridiculous. This morning it was 29 degrees out, 28 degrees out, but it was warmer before. This is, the Midwest is the melting and refreezing capital of the center of the United States. It's just the way our weather is. And if you're a business owner, you know that, and you look at the parking lot and you put ice melt down, you shovel it, or you pay people to, because you want your business to be safe for your guests. That's what the law says, and as it should be. We do not want that to be dangerous to people ever, right? So that's what you do. And contact us, and we do other things. So we ask for the security tape. We ask for witnesses. Oh, when you go notify the owner of the business, make sure you say, hey, give me the names of the witnesses. Take pictures of the stuff. Make sure they got their information. Say, listen, what do you know about this? Oh, you know what? This vegetable rack, we had this case one time. Lettuce is always falling down from this. So, or they say, what I told that guy to do it. You know what? We knew about that puddle. It's raining. We know that people are coming in tracking water in it. I just had one of our employees go mop it all up, but they never put out the wet floor sign or the piso mojado. That's just what they always say in Spanish, piso mojado. The wet floor sign was over against the wall. No one was going to see it. They forgot to do that. Or, oh my gosh, I told them about it. There was a soda there, or ice melting out of this. Well, we know this ice is always leaking out of. There's all kinds of stuff you find that where the owner really kind of should have known, and they should have done more about it. We're not saying they're bad. We're just saying they were negligent that day and caused injury to our client. That's how you make a claim. And the problem is, in some of these slip and falls, is if you don't do it, if you don't notify the building owner or manager or homeowner, if you don't get a lawyer right away and you start looking at this like 3 months later, that evidence is gone. The security tape is written over. The witnesses, there were 3 witnesses there. No one got their names and numbers. You think they did. The manager didn't write it down. You didn't take pictures. So you got to be a little bit on your own in terms of getting the evidence right away in your own case. Sometimes you don't know because you fall and you're hurt, you're a little embarrassed, you get up and go away. You don't realize till the next day, you're like, uh-oh, I threw my back out and now I need back surgery. Or you don't realize, boy, I thought it was just a bone bruise, but I fractured my femur. Get the evidence you need right away then on the if come that your injuries are going to be more serious than you might have thought initially, and you're going to need to make a claim. You need to do that because these cases are aggressively defended. We fight them all the time. Very often we're filing lawsuits and litigating these cases. And we have to fight these cases hard. It's crazy. All right. So let me go to another question. We're almost done with time. It's 12 o'clock. I started a little bit later. Pastor Jack. Hello, Pastor. Thank you for watching. Brennan. So let me just close about bees. So I happen to be a beekeeper. I'll tell you what, here's what I'm going to do. The first person who makes a comment in this chat right now is going to get a free thing of honey from me. Make a comment here, say, I get the honey. The first person who does, who's still watching after listening to my boring talk for 55 minutes, leave a comment, give me your email address. We're going to email you. We're going to get your address. I'm going to mail you a bottle of Gary's Gold. I called my gold this year Gary's Gold. Hey, Ken, how you doing? Ken Masigan, you get the honey. Here's the second thing, Ken. I need you to testify at trial, at our trial on January 8th. Excuse me, June 8th, 6/8/2022. I want you to be one of my first witnesses at trial in the Department of Corrections case. So we have your email address. I have your physical address too. So Ken, you're getting a bottle of gold. So thank you, Ken. Let me go to my, Lori Munoz. All right, Lori, I'm going to do two. Lori gets honey too. Lori, give us your email address. So this year I got 120 pounds of honey. It's great. I've given some away. I got to get my act together. I usually give it away from the holidays. I don't sell it. I give it. Oh, honey. I give it away. Thank you, Kaylin. I did really good. Our bees were really good this year. It's good. So what do you do about colony collapse, and what do you do about bees in the winter? So I'm going to close it out for about 3 minutes. I'm going to talk about it. So bees make honey so that they can eat over the winter. In the winter, the bee colony goes down from like thousands of bees to hundreds of bees, and they get around in a ball and they vibrate together and they keep themselves and the queen warm all winter. They don't go away. They're living in there. So in your hive, it'll be 80, 90 degrees, and it's like 10 degrees outside. It's amazing what they do, these honeybees. So what I do to prevent colony collapse or to help them over I know you don't work at thank you for telling me you don't work at the DOC anymore. I hope things are good with you, Ken. I love telling Ken's testimony at the last trial was amazing. You're gonna do it again, Ken. You don't need prep. You're ready to go. Back to my bees. I look like I have a bald spot on my head. Anyway, I'll put some pictures up of my bees and my beehives. I'm going to go feed them. So here's what I do. Two main things. One is I feed them sugar water. I give them sugar water, about 2/3 sugar, 1/3 water, sometimes half and half, and I give them amino boosters and honeybee healthy stuff in it. And they drink the sugar water, fill their hive up, and they store the sugar water in there instead of honey, and they drink the sugar water. You can also give them pollen packets if you want to. Sorry, let me give you my other art wall too. So we do that. The second thing is to do is so colony collapse happens because there's these little tiny mites. They're called Varroa mites, and they get onto the bees. It's kind of like a tick on a dog or tick on a human. And what the Varroa does is it's a pest. It's a pest to them. But the second thing it does is the Varroa gets all the pesticides in our community. So all the stuff you put on your lawn, all the stuff farmers put on, the Varroa is loaded with pesticides and poison, and then they leach onto the bees and they dose the bees with that poison. So what I do is I treat them with different types of chemicals to kill the Varroa and keep the leaves so that the Varroa are dead. And then so we control the Varroa, and that helps the bees through the winter too. Last year I had 2 of my 3 colonies came through winter. Great. And actually all 3 did, but then one of them was weak and I lost it in March, but then I redid it. But I've requeened my hives. I have 3 strong and 1 weak hive right now going into winter. My guess is that the 3 are going to make it, but the 1 isn't. And I'm going to go give them, I'm giving them a bunch of sugar water, and I'm going to treat them one last. I already treated them with Varroa. I think they're good on that. So anyway, listen, folks, it's right at an hour. Thanks, everybody. I really appreciate it. If anybody has any other questions, lawyer questions, we always answer questions for free, and we truly mean that. So you call us and we'll answer your questions for free. Holler you, and we'll do another one of these shows in 2 weeks. Thanks, everybody.